We will have a moment of silence followed by the Pledge of Allegiance led by myself. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Deputy County Manager Enrico Grati or Director Nicholas Ham, are there any changes to the agenda?
Madam Vice Chair, there are no changes I'm aware of to today's agenda.
Thank you very much. I move, moving on to number 4, approval of minutes. I move approval of the November 15th, 2022 zoning meeting minutes. Do I have a second?
Second.
Thank you. All in favor? Madam Deputy Clerk, please call the roll.
Thank you. Commissioner Benson?
Aye.
Commissioner Olivas?
Aye.
Commissioner Quesada?
Aye.
Vice Chair Barboa?
Aye.
Madam Chair Baca?
Aye.
Thank you. Thank you. Moving on to 5, the NAO appeal. We will proceed with the quasi-judicial appeals process restricted to the parameters set for staff and appellant presentations. This process does not permit public comment and new evidence will not be accepted. For the planning development, Misty Garcia, personal representative of the state of Misty Thompson, appeals the Board of County Commissioners, approve a resolution AR 2023-84. We will proceed with an abbreviated version of our standard appeals procedures as follows. One will have staff presentation for 5 minutes. Then we will have the appellant's presentation for 10 minutes, staff closure 5 minutes, board discussion and question, and then we will take action. Before we start with staff presentation, Madam Clerk, please swear in all those giving testimony today.
All those providing testimony, please stand up, raise your right hand, and repeat after me. Do you solemnly swear or affirm that the testimony you are about to give at this hearing shall be the truth and nothing but the truth under penalty of perjury?
I do.
Thank you.
Thank you. Go ahead. Director McCann.
Greetings, Commissioners. Good afternoon. Nicholas Ham, Director for Bernalillo County's Planning and Development Services. And Julianne, if you don't mind, I'd like to show some photographs over here. All right, so we have before you this afternoon, this is ENFC 2018-0022. It's an appeal relevant to the address 1325 Lopez Road Southwest. This is an appeal of an already approved resolution to enter and remove unsafe structures from the property in question. The appeal was originally intended to be heard on 10/24/23. However, the applicant claimed to not be well enough to appear, and the previous hearing was rescheduled to today's date. Enforcement by county staff began on this property in February of 2018. This was after complaints were received from the community indicating unsafe structures. The structures were ultimately confirmed to be unsafe in a dilapidated and unsecured state by county staff. The structure was placarded as unsafe to occupy, and the owner was notified of the need to bring the property into compliance. The original owner passed away in around 2019, at which time the county granted time for the requisite probate process to run its course. The current owner or the responsible party began to take the property over in 2019 with full knowledge of the violations present on the property. The enforcement case was eventually forwarded to the Nuisance Abatement Office for their consideration. This was on 5/8/23. The property was posted for initiation of enforcement by the Nuisance Abatement Officer on 5/23/2023. A final administrative enforcement order was posted on the property. On 6/21/23, the first nuisance abatement hearing was convened. The hearing officer at that time determined the property to be a nuisance and recommended a resolution to the Board of County Commissioners for its remediation. The board adopted the recommended resolution on 8/8/2023, allowing the county to use its authority to remove identified nuisances and to file a lien for costs incurred. The resolution that you ultimately adopted identified 14 conditions from the county's adopted nuisance abatement ordinance that constitute a nuisance and unsafe conditions for the health and safety of the general public. This decision was appealed back to the nuisance abatement hearing officer. That was heard on 9/20 of 23. The hearing officer who's present today to answer any questions found the property to still be a nuisance. Her findings indicate that the previously approved resolution should be enforced. That leads us to today's proceedings. The property has now been deemed to be a nuisance or unsafe by the county's code enforcement coordinator, the county's nuisance abatement hearing officer, the county's certified building official, the county's fire marshal, the county's nuisance abatement hearing officer, and as well as the Board of County Commissioners. 5 years have passed since these unsafe conditions were brought to the owner's attention. This includes at least 10 inspections of the property and 12 notice of violations sent to the property owner of record. I'm going to yield the remaining 2 minutes of my time to the fire marshal. Deputy Chief McConnell is here to testify at their findings. They've been working with us on this property since it's in such a poor condition.
Commissioners, so I'm Deputy Chief Mark McConnell, also was a fire marshal for the majority of this case. So this building presents an immediate hazard to the public as well as to firefighters. As you can see in the picture that we presented, it has a red X on it. That red X is put on there by fire code to signify that it is structurally unsound, and by entering that building, it puts us at risk. Now, we see that fire code is actually made throughout the nation as a proactive approach instead of an active approach, unfortunately. And we've done this code is currently in place because we've seen firefighters and we've seen civilians die in these type of buildings. This building is not structurally sound, and what our major concern is there's no way to keep the public out of it. Whether it's indigent people who are looking for warmth or kids going in after school and just looking for something to do. If any hazard ends up happening at this address and fire, which in my visits to the property, I did see fire violations that put the property at risk, like extension cords that were overloaded and burning. If this property was to catch fire, my concern of our firefighters going in there to try to save someone, it would collapse and kill our firefighters. I think this presents an immediate hazard to us. And so this building is marked by red X by the county fire code to signify that.
Thank you, Deputy Chief. I'm going to take the remaining time that I have to just scroll through these pictures very briefly. This is a close-up of the red X that was discussed previously. So this is a 3-story adobe structure. It doesn't have a foundation. It's listing and bowing in a number of places. It's on a property line, so if it were to fail or collapse, it would fall onto another property owner's property. There's instances here of the walls cracking and bowing. This is a side profile of the structure. This is the portion of the building that's adjacent to the immediate neighbor's property line. So if you look just past where the fence is, that's someone else's property. This is probably kind of the worst facade of the property. It's just, there's not a piece of this property that isn't failing in some way or deteriorating from the elements. And it's every time we go out there, something worse is found. Last time Deputy Chief was out there, they found a extension cord plugged in sort of an unsafe way amongst a couple of leaves, presenting sort of one of those situations where you hope never happens, but could easily have turned into a structure fire. A close-up of some more of the walls that are failing and cracking. Again, these are the walls that are against the adjacent property owner's line. You can see them bowing inward and outward in some places. Additional cracks are forming here. This showing exactly how close it is to another county resident's property line. This one particularly well shows the bowing outward of the bottom floor, indicating that the structure's failing. And then these are just pictures of the general disrepair that occurs throughout the rest of the property. We've had a number of inoperative vehicles and other unsafe structures removed from this, but there's quite a bit of work that remains to be done. And we ask your support to be able to go and finish this job.
Director Ham and Fire. We will move to appellant presentation. I don't know if you timed the time that Mr. Ham got. Okay, maybe we could add that to the. Thank you so much for your presentation.
Madam Vice Chair, they don't appear to be present.
Oh, I thought someone who stood up and raised their hand must have been there.
For the next case.
Okay.
Madam Chair, can we ask questions now?
So if we don't have that, and we would have staff closure usually after that, I don't know if you want to proceed with closure, and then we would have board discussion and questions.
Sure. Madam Vice Chair, I'll just add that we had correspondence with the appellant by mail, by email. I spoke with her as recently as Friday, indicating that I'd see her on Tuesday for today's proceeding. So I don't think this is a situation of someone not knowing that this was going to occur. I'll also add that I've got a number of county staff that have worked on this property. If you want to ask specific questions of the hearing officer, of the nuisance abatement officer, of the county's code enforcement coordinator, we're all prepared to answer any detailed questions you might have about the structure.
Okay, then we can open up for discussion. Sounds like Commissioner Quesada.
Thank you, Madam Chair. Yeah, I guess my first question was going to be when I first showed the first picture is what would it take to get to compliance? And after seeing the other photos, I think I probably answered my own question. You know, I think the big thing for me is, you know, public safety for our public safety people, right? I mean, for our fire department, our police department. I mean, I couldn't imagine even trying to kick a door down and going in there, trying to, you know, clear people out of there, how dangerous that appears to be. You guys know I always fight for my constituents first, and I always do, because, you know, a lot of these families come from generations of just, you know, that's what they have, that's what they own, that's what they got, and it's really hard for me to sometimes look at that, and so I'm always looking for a way to help, right? I just don't see it on this property, unfortunately. You know, the red X alone just kind of puts our firefighters in too much danger. Their job's already dangerous on a regular home. I couldn't imagine a home like that. So I guess my question is, I'll ask it anyway so you could publicly say it. What would it take to get this property into compliance?
Madam Vice Chair, Commissioner Quesada, the county's position has always been that the only way to make this property safe and compliant with the nuisance ordinance is removal of this structure. Like I said, we've had the county's building official. She's the head of the building department. She holds certifications in all aspects of the building code. She's got at least 30 years of experience in the field. Her own personal findings on an inspection were that this structure could not be saved. We explained that to the property owner. It's always an option for them to find their own professional, in this instance, a structural engineer that can make their own determination. There's no evidence in the record to suggest that ever occurred. So again, our position is that this structure needs to come down for the health and safety of the community.
Is there somebody living in there?
Madam Chair, Commissioner Quesada, there was an individual, well, I guess a number of individuals that resided on the property. Some of them were in either recreational vehicles or sort of makeshift structures. There was what we understand to be a relative of the property owner living in one of the structures on this property that is in okay shape.
But not in that building.
The county would not be displacing anyone from their home by taking down this particular structure in question.
And what's the deal with the RVs on the property? Would that also have to be cleaned up, taken out?
Our intention would to remove all nuisances from the property to make this as safe and as compliant as the county can. And if there are vehicles of historical significance or they're functioning, those would be things that we leave alone. But if they're, I guess how we would constitute as trash or a junkyard vehicle, those would be things that we'd also look for our contractor to remove.
So when we go in to remediate this property, we are going to ask for the removal of these temporary shelters, these RVs. You're going to ask for that as well?
Madam Chair, Commissioner Quesada, anything that does not constitute a structure that's safe through the prism of the building code or the nuisance abatement code, those would be structures that we'd include in our scope of work for the demolition contractor.
So yes is your answer?
The short answer to that is yes. Anything that's unsafe, we would suggest needs to come.
I have a little heartburn on that one, Mr. Ham. Just because, we're dealing with housing difficulties on our own up here on a separate issue. I think it makes me happy that nobody's actually living in that structure because, you know, that would just be crazy dangerous. And I think we're doing that person, if there's somebody in there, that person a favor, unfortunately. I wish there was something we can do about these other, if people are actually, if that's where they're living. I think this is better than a sidewalk or a, you know, I have to look at this from all sides.
If I might, Commissioner?
Yeah.
So our primary concern is this three-story structure with the red X that presents a hazard to our public safety officials. That is really the reason that we're standing before you today. The other items, those we could address through the zoning code or other ordinances that the county has adopted. Our primary concern is the structure that's in danger of collapse.
Okay.
That's why we're here before you today. So if the wisdom of the board were to narrow our department's action to that structure in particular, I can say with full faith that that's something that we would leave happily today with.
Okay. Thank you, Mr. Ham. I appreciate you.
Madam Vice Chair.
Yes, Commissioner Benson.
I have a couple questions just out of curiosity. Director Ham, actually, Commissioner Quesada already asked one. I was curious how many people were living there. But when was the structure built? You said it was adobe? And so just curious when it was built and what's the square footage of it?
Best we can tell, it was built in about 1936. It's partially out of adobe. These structures, they don't have foundations or supports like contemporary structures would. It's just very old. And it's been left in this state of disrepair for a very long time, and it just continues to deteriorate. And Commissioner Quesada, back to your question, our inspector, Jonathan Aguilar, he's been the one that's leading sort of the field work on this for our department at least. He went out and checked on the property today. He didn't find anyone on the property living there.
And Director Ham, how many square feet is the house?
Mike, do you have an idea of how big it is? Our best guess is over 3,000 square feet. It's a large structure. It really is.
Thank you.
Thank you.
Madam Chair,
Yes, Commissioner Olivas.
just one question for you. Do you have any kind of, I know that when we do this, right, we place a lien on the property for the cost of demolition and disposal. Do we have any idea roughly what this is looking like? What kind of burden the property owner's looking at?
Madam Chair, Commissioner Olivas, it would be in the tens of thousands of dollars range. We've received, so the property owner has already undertaken some of that action on their own. Like I said, there were a number of structures on this that the structures, they were all in this similar condition where they needed to come down. I will say that I believe that the county's bid process creates very competitive numbers for anyone, including someone that might have to shoulder the burden here. And unless there's a reason not to select the lowest number that the county receives, like they don't have the required insurance or they don't have the appropriate license, that's who we select. We have zero interest in creating an additional financial burden beyond just removing the structure that presents a health hazard.
That seems like a fairly reasonable number for a structure this large. Thank you.
You said the property owner passed away in 2019, so this property wasn't sold, like it's within the family.
Madam Vice Chair, the original property owner, I believe the name was Misty Thompson, is that correct? They passed away in or around 2019. Their heir, and we're not crystal clear on the relationship. Her name is Misty Galicia. She's the one that took over this property as a personal representative. And that was in or around 2019 as well. So it's been a number of years.
Okay.
Here she is.
So, given that she's now here, do we go back to Julie? I'm asking, Are we allowed to go back to?
I will defer to county legal on whether we're going to go through the process again. We'll defer to you as the chair if you want to hear from the appellant.
Okay, well, welcome to the space. And we were just about to close our discussion and move on to action. But I will give you, you have 10 minutes in this process to appeal.
Thank you. I'm a little sheepish. My apologies. The last thing I wanted to do was inconvenience you all. I'm
Madam
very
Chair.
sorry. I just came in from California.
Madam Chair, my apologies for interrupting, but we will need to have her sworn in. And if you can make your way to the podium so that you can speak into the microphone. Madam Clerk.
Where's the clerk?
Thank you, Madam Chair. All those providing testimony, please stand up and raise your right hand. Do you solemnly swear? They've already sworn in. Okay. Do you solemnly swear or affirm that the testimony you are about to give at this hearing shall be the truth and nothing but the truth under penalty of perjury?
I do.
I do.
Thank you.
Okay, thank you. You have 10 minutes.
All right. Well, I will speak faster than I had planned. Again, my apologies. I thought the notice of hearing for today was 4 o'clock, and that on the heels of your gracious agreement to allow me to defer the hearing because I was ill at the last one. So again, I thank you for that. I apologize for taking up your time unnecessarily. That was my mistake. So without further ado, I would like to address each of you regarding this issue with the Lopez property. And I will refer to my notes occasionally because this is an important matter to me. So forgive me if I have to do that. You know, the process to be heard today started at a nuisance abatement hearing, which I attended. I don't live in Albuquerque, and so whenever I come, I do travel quite some distance at quite a bit of expense, and I appreciate the opportunity to be heard. I first was heard at the nuisance abatement hearing by the hearing officer. Then I came here for your board meeting when this matter came onto the agenda. Apparently came on as a consent item with many other matters. And I wasn't able to address you at that time. It went back to the nuisance abatement officer. I attended that in person as well. And so I'm here today because, as I told you, this is an important matter to me. And I know the zoning department, although unfortunately I wasn't present for their presentation, but the last opportunities that I did have to hear them and to see what they were presenting, you know, it clearly is a significant amount of information that you have before you from the zoning department. And I'm going on the belief that it will be consistent with what you've previously had before you. What I would like to do is just maybe step back for a moment for context. And I want to just point out that this building, this 3-story building, was a building that was prepared, was actually built by my grandmother for returning veterans of the war so that they would have some place to live. And in our family lore, the property was actually, she was more likely to feed these returning servicemen than she was to collect rent from them. But this was the service that she provided in the Albuquerque community. And from there, she called it, I believe she called it like Lodge in the Valley or something like that. And she actually housed my uncle, who was a runaway kiddo. She took him under her wing. He had a sister who was my mother, who met my future, her future husband, which was my father. So this is the property that we're talking about. And in the 1980s, what happened is my grandmother had significant injuries due to a burn. In the South Valley, has absolutely captured the attention of the zoning department all of these years. And bear with me, this actually has some relevance, right? Just stick with me for a couple of minutes. Meanwhile, in 2012, the Water Authority, the Bernalillo County Water Authority, I'm aware it's a different entity. I'm not trying to tie them together. I'm just giving you context. In 2012, they initiated a lawsuit with my father, who's now deceased, obviously. And for years, this litigation was ongoing. It would languish, the court would dismiss it, the Water Authority would refile it. They racked up thousands, tens of thousands, hundreds of thousands of dollars worth of liens. And so against this backdrop, right, is where I came in, unfortunately after my father's death, as the personal representative of the estate. So where am I going with this context? It's simply this. The request presented by the Nuisance Abatement Office is premised on a faulty assertion. And what I mean by that is, in the administrative resolution number 202384, which is before you today, it says, whereas, you'll see it in there, when an owner fails to cooperate in cleaning their property, the nuisance abatement ordinance provides a framework and the necessary means to enforce the county's authority, because of course the county has the authority, right, to regulate a legitimate state interest or county interest in the safety, the public safety. However, my contention today is that each one of you, you have to make an affirmative finding based on the ordinance, not based on what I'm telling you, but based on what the New Mexico County ordinance says. And the finding that you have to make is that I have failed to cooperate in cleaning the property. And I'm here to tell you that you will be hard pressed to make that finding. And here is why. The reason I gave you all of that context is because, ironically, standing before you is the only Thompson who has willingly engaged with the zoning department to productively and collaboratively address their concerns. On the litigation side, I engaged an attorney. I worked with the litigation with the Water Authority so that I could bring that to a close, that the judicial resources that have been used for 12 years, right, that we could quit doing that. And so I retained counsel. That's a significant task. That's a responsibility of the personal administrator. And that's something to take into context with these other issues with zoning. Because this isn't just an issue that is it was like the only thing that I had to focus on. In addition to the fact that I'm a single mom, I have school-age children, I live out of state, and I've made significant progress, and I continue to do so. So let me tell you a little bit more about that progress. So on May 19th, Mr. Aguilar and I had a conversation. I regard that as kind of of this year. I regard that as kind of the first step in demonstrating the first conversation that I was aware of that I had with the zoning department on this issue. Do you realize that's merely a few months ago? When he called me, the immediate thing I told him was that I was interested in working with him, that we were gonna move to a resolution, and that I lived in California and that my children would be out of school in June, like a month away, and that I would absolutely, take care of what needed to be taken care of. And he told me at that time that he would not, that the process wasn't going to wait for me, right? Fair enough. But that the process, and by the process I mean the requesting this order to come onto somebody else's property and under these draconian measures, enter the property, demolish, remove, and put a lien, which is subject to foreclosure, right? So we're not talking about some, minimal impact on a property owner's constitutional rights. We're talking about a significant imposition. So at that time, I told him that I would come and do what I needed to. In the meantime, what I did was I flew out for a 2-hour window while I dropped my kids off at school. I flew out here, I met with a contractor, I flew back home. I actually acquired several bids. I continuously communicated with Mr. Aguilar and with the zoning department because, I read the ordinances, and it suggests not only that there should be cooperation, but that it should be collaborative. So I told him as soon as my kids were out of school, I would come out here, and on June 9th, I secured the permits. So I did exactly what I said I was going to do. I came, and it's more than just like taking down the building, right? So I had to hire labor besides myself. I had to rent a dumpster. I had to spend all of the time and effort that it took to do a lot of the cleaning. I selected my contractor. I recycled some things. I organized some things, and I took down the 2 buildings. Unfortunately, that did take me 2 months. and I was not able to finish at the rate in which I thought I was going to finish. And so I left Albuquerque to go back, and I've come, as you know, for every hearing, well, except the last one in which I was sick, but I continue to engage in the process and engage in my administrative remedies. And so all of those reasons are why I say for you to make an affirmative finding that I have failed to cooperate in cleaning the property, I think you'd be hard pressed to find that. So the next thing I just wanted to talk about was my expectation based on the statute that there would be some sort of collaborative effort to come up with an action plan. And I didn't make that up. Chapter 11 is replete with language that talks about an action plan and engaging in this collaborative process. Is that my 10 minutes? Okay. So then I will summarize my arguments. The county, I believe, did not, in good faith, enter into this collaboration. 5 times I asked. Immediately when I spoke to Mr. Aguilar, I asked him and he said, sorry, we're not gonna slow the process down. You need to take care of it now. And I responded appropriately. I asked Mr. Granati, and I was told that he wouldn't engage in the conversation. I asked, who is your lawyer? So my lawyer can talk to your lawyer. And I was told, oh, lawyers don't get involved until later. I asked 4 days ago, look, all we're talking about is timing. Is there something that we could do to agree on what we could do? And I was told, no. Every single overture that I made I didn't see a response that was consistent to my expectation given the statute. So I have barely 13 seconds, but I have to bring up this issue of notice because due process requires notice and an opportunity to be heard. And on the face of these notices, there is ambiguity that doesn't tell me. Will there be rebuttal? Well, we'll have a time for staff closure. And I'll have an opportunity to do close as well?
No, sorry, let me turn on we had a staff presentation and they got 5 minutes, and they took that time. Then we have, your 10-minute time, and then we close, the staff gets to close with a 5-minute.
I don't really want to challenge you, but I read it differently. Okay.
That's our process, but we will have time for the board and staff to discuss, and commissioners can call you up for more questions if that's what they choose to ask.
Thank you. I appreciate it.
I will allow for, get your 5 minutes back for staff closure.
Madam Vice Chair, Commissioners, I will be brief. The notice, I'll start with one point. The notice of hearing for today clearly indicates 3 o'clock. Julianne, while we were listening to the presentation, confirmed that our Public Information Office notified this as a 3 o'clock hearing. The question of notice has been brought up a few times through this process. We are not aware of a single defect in the notice. In fact, we've gone over our statutory burden as far as notifying the party that's here today. Through direct email communication, we've sent things through mailings and certified mailings. We've posted everything on the property, and we have photographic evidence of that here today if we need to look over that. I think it's fair to say that Ms. Galicia did cooperate to a certain extent, but not to the extent necessary to abate the safety and health concerns of the county. You heard it from our deputy fire chief today yourselves that this structure is incredibly unsafe, even for emergency responders that are trying to save people's lives. It's our position that we've given ample time and cooperation. She's had 2 hearings in front of the nuisance abatement hearing officer. She's had now 2 hearings in front of you all. We've accommodated almost every request for rescheduling or additional time to accommodate this individual's schedule. And in my thought, as someone that administers this process, we've probably waited too long here. This is a structure that's so dangerous that we should have originally probably thought about using our emergency authority to take this down. But we erred on the side of process and property rights, and we gave ample time and opportunity for them to come into compliance on their own volition. We just don't have the results to show you all today. Hence, our appearance and our ask today is to let us close this gap or close this process and remove a structure that's unsafe for the residents of Bernalillo County. And I'll stand for any questions.
Thank you, Director McCam. Any comments, questions? Yes, Commissioner Quesada.
Yeah, Madam Chair, Ms. Galicia, do you have those quotes from these contractors that you met with?
Yes, yes, I do, sir. So the first, in terms of timing, you can see that the date on this one is May 24th. Oh, can you? Sorry, I don't know how to use your document camera.
Yeah, neither do
I
I.
think Julianne's helping us. Somebody will. Is that your picture?
So the document camera is not responding.
Oh, may I approach?
If you want to hand them to me, I can share them with the dais.
So, so what I'm providing you with is a bid from Coronado, a bid from Eco Green, and I'm sorry, the third bid doesn't appear to be in my file.
Thank you.
So I guess my follow-up question as we look at that, Ms. Galicia, is are these quotes to demolish the property?
Yes, sir. And the demolition is in process, I guess I would say. In other words, I engaged one of the contractors who came with me here today, and I completed not just demolition, but I filled in an area that was a hazard. I cleared the property. I left it, what do you call it, like rake, whatever. There's a term that people who do demolition call it. But I mean, I left it in excellent, my contractors left it in excellent condition. I put significant effort to make sure that the property was in place. So I regard this as in process, and I have every plan to complete the project.
I don't have the quote yet, but what was the price? What was the price?
So
Oh, okay, you have them blacked out?
I redacted them.
Yeah, okay, all right.
I actually did that because I felt like that would protect the people who gave me the quote.
Okay.
But if you're requiring that information.
Well, you know,
This was the, if I may.
I was just trying to compare this to what we thought earlier, what a quote would be for us to do this.
What is it for the last building? Oh, I see. I should give you information too. That's
Well,
fair.
you know, I guess it
It's
wouldn't
fair.
be, I would have to ask our attorney if I'm able to disclose what I heard. I mean, if you were here, you would have heard it. It's already public record, correct? And so it wouldn't matter. Commissioner Olivas asked about the price, and it was 10,000 plus, maybe? It was a guess. So it's
I
not
see.
it's not a real quote. I could see through the black ink that it's a little more than that from your quote. You know, this is my district. So I take it very seriously about making sure that, you know, these are historic places, these are historic residents. You know, a lot of times it's families who, that's all
Madam
they
Chair?
have.
My apologies for the interruption. I think we need to defer to staff or legal on this because I understood that the quotes were not in the record. And so if this is introducing new evidence, but I'll defer.
Yeah, no, I didn't say their quote.
No, I understand what she submitted.
Oh, okay. So
Matt.
what, you want us, you can't submit these is what we're saying?
Madam,
All right, I'll just pretend I didn't see them and I'll finish my comment. I guess, you know, I guess it's really irrelevant, I guess, to the point where I just wanted to make a statement that, you know, I really fight hard for these properties and making sure people have somewhere to live. You know, we come from, and South Valley's historic, where it's generations of people who, you know, have struggled a bit And that's what they have. But from my understanding, from the evidence that I'd heard from the fire inspector, and now he's a deputy chief, but, that it's beyond that point. But I feel for you because I really feel that there is somewhat of an effort. We normally don't get that much of an effort, but do I make a decision based on public safety as a whole? And so that's where I'm I have mixed feelings on this. I think you did do that. I don't know what this commission and the will of this commission is going to be. But perhaps if there was a timeline that was very expedited, that would be something that I would be willing to listen to at this point. Because at the end of the day, just from the photos alone, it's a very dangerous property. And I would feel very sad if it caught fire and I lost a firefighter in that. I would feel very sad that if I didn't take action today on that property. I think you had valuable information and valid arguments as well. But the process is the process. I also have to abide by those rules as well. I wish I didn't have to sometimes. I think we all do. And so I just wanted to make that comment to you that I heard you. I understand, how difficult it must be coming back and forth to California. I mean, that spoke strongly to me, your dedication to this. But at the end of the day, it's really going to be the will of the commission. But I want to thank you for showing up and standing up for yourself. And unfortunately, I guess this evidence doesn't matter at this point. So I have to make a decision on what I heard. But, it's a shame because what you told me about the historic meaning to this property even hurt my soul a little bit even more right now, to be honest with you. But I think what we're both come to an agreement is that it has to be gone. And that's also your plan too. So, but thank you. And I'm so sorry.
May I respond, Mr. Quezada?
Yes,
Madam Chair, may I respond?
yes.
Thank you. I agree. I think the process is important, right? I mean, that's the whole point of due process, that the process has to be meaningful and you have to have a meaningful opportunity to engage in that process. And so my ask today really is that you would, I think if there's an order in place, I would be asking that you resend it and that you instruct the zoning department to engage in this collaborative process so that I do have an opportunity to make an action plan, because I have the same concerns. As I said, I unfortunately didn't hear what the fire chief said, but I believe it was similar to what previously was stated, right? Which is, here's a building that nobody wants to send a firefighter into. Let's be clear, nobody is living in this building. There are no squatters in this building. There's no graffiti. There are no vagrants. There's been no entry. There's been no evidence of any of that.
Make it quick. Sum up your response.
So I have the same safety concerns, and I think that they're valid. I just think that there's another way to address them, and I would like the opportunity at least to try to do that. Thank you.
Yes, I'd like to ask Mr. Nakam.
Madam Vice Chair, Commissioners, thank you for the opportunity to answer the question or address the question, I suppose. A couple things that I want to point out. The demolition permits that were pulled have a shelf life. They're both expired on this property. What we would be comfortable with is to extend those through the time period that the county would have to undertake its bid and demolition process, which takes us to, I'm going to play it safe and add a few weeks, February 1. Okay, and we would, at free of charge, reopen her demolition permits, allow her to take down this property or this unsafe structure of her own volition, and give her an opportunity to do that before the county could get to it. But beyond that point, I have to agree with Commissioner Quesada and the rest of the board's comments about the safety of the public safety staff, the safety of folks that in the colder months are going to be starting to seek shelter in structures like this. And in fairness, the liability that Galicia retains by having this structure on her own property. We've never been in a position where we don't want to be reasonable about a timeline. But our thought is that at some point, we reach a point of diminishing returns and we become culpable ourselves in allowing this structure to remain. So I would, in the spirit of cooperation and community service and us just wanting to get the job done, the department could agree to February 1, which would be essentially the amount of time that it would take the county to get to this structure through the process that we have to undertake to go through the bids.
I think that feels very generous. Thank you, Ms. Director Ham. Is there any comments or questions? Is there any process we need to, and anyone objections to that? What I think is pretty graceful. I think, February 1st might feel also, I do think, thinking that, June, as you said, was the timing that the first sort of determination was made. Even though 2019, like you said, people said they were aware. So we've been informed, right, that you have been aware. You said that May was the first communication, but we were understood that you had, since 2019, you've been aware of the various, like you spoke to, other liens and other things that you've had to deal with. I think February 1st is very generous, and I guess, is there any process we need to do to change that to February 1st, or does it just, do you all extend it? Looking to legal or?
Madam Chair, just a suggestion. If you make a decision for denial of the appeal today and to enforce the resolution, it would take the county at least through the beginning of next year. And I would say under sworn testimony on record that the county would not engage its contractor before February 1st. And if you feel the need to put that in the deciding resolution here, the department would have no objection to that language being inserted.
Okay, no, thank you for that clarity. I think we are good to move forward with the denial, and I hope you understand what's being permitted at this moment. Ms. Galash, sorry, I won't get your name right, Galicia, we're gonna pass, we're gonna make a motion, we'll see what passes, to uphold what is currently being ordered. But that what I believe Director Nakam is saying is that you basically have until February 1st to avoid that from happening, if you were able to get this done before then. That would avoid it altogether. Any questions, comments? Clarity?
So I think in the alternative, you could actually, I think you can achieve the same thing perhaps in a little more streamlined method by deferring your.
I understand. Thank you. If there hasn't been a motion by any other motion, I can make a motion to deny the appeal and uphold AR 2023-84, approving the entry, demolition, and cleaning of the nuisance property located at 1324 Lopez Road Southwest. Do I have a second?
Second.
Any more comments? Okay, Madam Deputy Clerk, please call the roll. Oh, did you want to talk, Commissioner Casada? Okay. Madam Deputy Clerk, please call the roll.
Thank you, Madam Vice Chair. Commissioner Benson.
Aye.
Commissioner Olivas.
Yes.
Commissioner Quesada.
Aye.
Vice Chair Barboa.
Yes.
Madam Chair Baca.
Yes.
Thank you. Thank you, everyone, for your commitment and hard work. You have a roll. Okay, we are now moving on to item number 6. We will now proceed with the zoning appeal and appeals procedures as follows. Before we start with the staff presentation, Madam Clerk, please swear in. Oh, we've already sworn in. Is that
Carl's gonna go fast.
good? Okay. Planning and development, staff presentations.
Okay.
Madam
Everybody's
Vice-
here that has been sworn in. Is that correct?
This case is ready.
Thank you.
Does she need to read all this out? She has it. Do you want to?
Is that what you're asking?
The appeals procedures.
Oh, yes, I do. Yep.
if you want to
Oh,
read them into the record at
sorry,
this
I
time.
see it now.
Yeah.
Thank you. Sorry, I haven't chaired for a while. I will get back at this. I will first read in appeals procedure into the record. The next item on the agenda is appeals. The first appeal, this is an appeal based on the evidence in the record. Ordinarily, no new evidence will be accepted before the county commission. However, in the event that new evidence or testimony is accepted, the clerk will swear any witness who may testify concerning it. The order of presentation and time limits is set forth in our rules of procedure as follows. Staff presentation, 5 minutes. Appellant's presentation, 10 minutes. Opponent's presentation, 15 minutes. Appellant's summation or rebuttal, 5 minutes. Staff closure, 2 minutes. Board discussion and questions, and then 7, take action. Please aware that the time limits for each side, appellants and opponents, is the total time allowed regardless of the number of persons signed up to speak. So each side will need to decide on how to divide the total minutes among the speakers. This is a quasi-judicial proceeding. The commission is to act as judges of the particular facts concerning the parties before it, applying existing laws into the facts. The commission is to base its decision only on the facts presented to it by the parties and not any facts supported by it that may exist outside the proceedings. The commission is to act with impartiality toward each party, applying the law of the facts without favoritism or bias or the mere desirability of given results. A commissioner with a financial or family interest in the outcome of a quasi-judicial proceeding should disclose any potential conflict in accordance with the rules and should, if necessary, recuse him or herself from the proceedings. The commission is rendering its decision should make a clear statement of what it believes to be relevant facts and why those facts led it to this decision. Each commissioner shall avoid ex parte communications with parties bringing cases before the commission. However, such communications that occur may be cured by the procedures stated in rule number 4. We will begin with the staff's presentation. Thank you.
Good afternoon, Madam Vice Chair Barbeau and Commissioners. My name is Carl Redman, and I'm a planner with Planning and Development Services Department. The item before you now is COA 2023-0009, which is an appeal of a special use permit, which the case number of that was CSU 2023-0009. This is an appeal of a County Planning Commission denial of a request for a special use permit for a winery, an on-site vineyard, and a single-family dwelling. The CPC denied the request at the September 6, 2023 County Planning Commission hearing. The BCC also considered a similar request for this property in 2021, again for a winery and a single-family dwelling, and that case was denied at that time. The subject property is a 0.56, so a little over half-acre size property. It's located at 1617 Barcelona Road Southwest, and it has a zoning of R1, which is a single-family residential zoning. The applicant of the special use permit, who is the appellant that's here today, wishes to operate a winery, grow grapes on the property, and then produce the wine on the property and sell it for retail purposes. They want to sell the finished wine to the market. The special use permit is required for a winery under Section 18 of the county zoning code. So currently the property is developed with an existing residence and a vineyard on the property, along with outbuilding like a garage, which is where the proposed production of the wine would take place. The single-family residence and the vineyard are both permissive uses in the underlying R1 zoning. The application for a special use permit included a site plan indicating the areas of the site to be used for a vineyard, wine production area within the existing shop building, along with the residence. Staff reviewed the request favorably as it was supported by many of the county's adopted land use documents, such as the comprehensive plan and the Southwest Area Plan, as those documents are supportive of these small scale businesses and the scope seemed appropriate for the area. However, the site plan that was provided was deficient with regards to landscaping and parking requirements per the zoning code. So staff did recommend approval of the request, citing the planning guidance for the area. However, this request did come with conditions of approval stating that the request should comply with parking and landscaping as per the code. The applicant disagreed with the recommended conditions and stated staff modified his application to include the language "with single-family dwelling" on the application. After a discussion about the request, the CPC voted to deny the request with findings of denial indicating the site is inadequate to accommodate the proposed winery and the applicant had failed to demonstrate the existing zoning of the property is inappropriate. The appellant appealed the decision of the County Planning Commission to the board. The appeal application specifically cited the addition of "with single-family dwelling" on the application being written by staff, as well as the conditions of approval as being not supportable. Again, the staff did recommend approval of the request to the County Planning Commission, subject to those conditions of approval that would make the site consistent with the surrounding land uses of the area, including the residential uses to the west and to the north. But again, the applicant has indicated the property is exempt from conditions of approval, which are a requirement for any commercial operation to mitigate potential impacts of the winery on surrounding properties. Therefore, staff reiterates the CPC's decision to deny the request. However, staff is prepared to present findings and conditions of approval, the same ones that have been presented to the County Planning Commission, should the Board of County Commissioners decide to grant the appeal and overturn the decision of the County Planning Commission. And with that, I will stand for questions.
I believe we now hear from the applicant presentation for 10 minutes.
Carl, can you pull up the application? Thank you.
The appeal or the original?
The one that you interfered with. It says with.
Let's see. Okay, so you can scroll through, but that's the application.
My name is Louis Hill. I am the son of Patricia Hill, and I am the grandson of Carmen and Faustino Barros, the previous owners of 1617 Barcelona Road Southwest. I am here to stand against the zoning department leading others into apostasy. Apostasy is a term signifying a renunciation of the codes, laws, principles, etc., supplemented by the federal government, and the adoption of contrary ones to cause scandal. In the adoption of contrary codes, laws, principles, etc., zoning no longer knows where government comes from, what it is, or how it is transferred by their practices. So I ask, can any of you tell me where government comes from? And I am also here to seek your conversion. Can anyone help? The first step in this conversion that I ask is to put a line through the clause "with single-family dwelling." After indicating to zoning my application for a winery and an on-site vineyard is not accompanied with or characterized with single-family dwelling, the zoning department wrote this clause into my application anyways without my consent. By putting a line through "with single-family dwelling" that is neither written in my pen, I used a black pen, they used the blue pen, nor is it written in my penmanship, you will send a clear message to the zoning department, which is, don't interfere in my application. In combination with the permit application, the zoning department has interfered with my business registration for an agricultural enterprise application, stating they will expire an annual contract within 30 days before it comes to term, delaying it since our last hearing. Because the manager says, and I quote, "it will not pass our inspection," they have already done things without my knowledge, which is why this is so important to bring up. No one could pass your misrepresentation of the codes. It all has to be amended to be brought back into compliance with the federal government supplementing the codes, laws, principles, etc. These two applications are the only applications needed for a county permit for a winery and an on-site vineyard, and to engage in commerce. Now, this is not the first time the zoning department interfered in important matters and led others into apostasy to cause scandal. The zoning department, sheriff, animal control, fire department, 911 emergency, and many others like APD interfered in 2 civil lawsuits I filed to abate the public nuisance of criminal drug behavior. As a result of my mom exposing the robber judge, Theodore Baca, signaling an attorney to steal from an estate in the probate of my grandmother's estate, following his predecessor, the current Robert Judge, Victor S. Lopez, hijacked my filing and replaced it with foreclosure laws. This cued attorneys, sheriffs, zoning, and animal control to lead others to apostasy by zoning the Mendoza's rental property in the county and Berlinda Padilla's rental property in the city of Albuquerque for lethal and illegal drug letting as a weapon to asphyxiate or suffocate us until they subtracted my family. These 2 court cases actually represent that the robber judges, even with Barella Shepherd being silent about the defendants suffering from cyanosis or cyanide poisoning at trial, they cannot steal or foreclose on my land using the lethal and illegal drug letting by the attorneys. The zoning department, sheriff, animal control, fire department, 911 emergency, and many others like APD leading these landlords and their tenants into apostasy. Therefore, this conversion requires you to follow an often narrow way between the cowardice which gives in to evil and the violence which under the illusion of fighting evil only makes it worse. This path is charity, which does not adopt the methods of zoning, but requires the practice of justice. For this end, charity does not create a heresy, but amends the zoning department and other people from the district courthouse of their bad doctrine, their deceit, their deception, and here, their misrepresentation of the codes, laws, principles, etc. And charities, one chief concern is to govern society for an ethical culture and not lead them to apostasy to scandal. That is, to cause scandal. Should you choose this path, let me be the first to say thank you for keeping God's people in your heart.
Thank you, and I will now we'll hear from the opponent's position. You have 15 minutes.
Madam Vice Chair, in this particular case, it's just the county and the appellant. There was no opposition.
Okay, so then you have 5 minutes.
Thank you, Madam Chair. First, I just want to say apologies for running over on time for this hearing. We tried to be brief, but obviously things didn't work out that way. Mr. Hill takes an issue with the county staff adding a notation to his application. I just wanted to explain that. He did indeed apply for a winery special use permit. It's a use that the county routinely considers and approves. His site plan that he submitted with that application, it also indicates that there was a house, a single-family dwelling on the property. The county has an obligation to accurately advertise these requested uses. So as indication that we needed to make sure that that appeared in the legal ad that goes to the Journal, in the agendas that go to you all, and in consideration of the findings and conditions that would ultimately be suggested, the term single-family dwelling was added to that document to accurately reflect Mr. Hill's complete application. We didn't, in any sense of the word, intend to modify or make it appear that those were his words. The county does that routinely to make sure that we advertise things accurately. It's our obligation under the law. The heart of this matter is, now this is the second occasion where the county has tried to approve this winery. We are in full support of Mr. Hill engaging in this business on his property with some very minor conditions of approval. Those being, for instance, a handicap parking space as required by federal law, buffer landscaping to protect his neighbors that have expressed concerns about this occurring next to their property. These are very modest things that are required of all businesses of this nature. Some of you all might be familiar with the Sheehan Winery, which is in this neighborhood. They have essentially the exact same sets of conditions that are imposed on them. So I was hopeful that Mr. Hill would come today and say that, he'd come around to the fact that, he could comply with the conditions, or most of them, or some of them even. And then we could work back towards some sort of resolution that protects his interest as a potential business owner and also the community's interest in their peaceful enjoyment of their homes. It just appears that we weren't able to get there. So we'll stand for any questions, and I appreciate your time today.
Thank you, Mr. DeCam. And so board discussion and questions.
Madam Chair, yeah, I've been here before. So I guess my only question would be to Mr. Hill is if this business venture is if it's something that you think would be beneficial and profitable to your family and to the future of your family, I mean, is it that important that we move forward with it under the conditions? Is it worth it to you to do that? I guess that's just a simple question. Is it worth it to go through all of this, these requirements in order to open your business and do it, or is it not?
The worth is in the section 18B31. By them adding that clause with single-family dwelling, they're sending me through section 18B32. Now, don't get me wrong. They're denying that they're sending me through section 18B32. There is another way. It's called lying. But it's one and the same with section 18B32, because the only way that you could change an R1 zone is into the only way that you could change an R1 zone into a commercial zone is by section 18B32. By their own testimony here today, they have grouped the single-family dwelling with the R1 zone. That's correct. But that's not my application. My application is for section 18B31 for a winery and an on-site vineyard for the cultivation of grapevines and to make handcrafted finished wines. This is absolutely essential for all the residents here in the South Valley as well as throughout Bernalillo County, that you cannot commercialize agricultural lands. It is our, and actually we have the Southwest Area Plan. Allow me a moment. This was an agenda presented on 9/21 of '04. The people who were a part of this was Della Gallegos, Bernalillo County Commission, District 2, Community Assistant, representing District 2, County Commissioner Steve Gallegos. There's a lot more people being presented on here. But the agricultural use of the land should continue as long as the residents desire to maintain this tradition. Guys, if you commercialize agricultural land, they won't be able to hire good people. They won't be able to even hire people at minimum wage based off of what they're saying on commercializing my land. You won't be able to sell wines at a reasonable price because of the first theft that they did to you. And that's what they're doing. They're commercializing the lands that we can't keep our agricultural lands, that because they want to thieve from us and commercialize it, then it totally changes what our objective and what our plans are for the future of this South Valley. And that's why this is so important.
Okay, thank you, Mr. Hill, I appreciate it. Mr. Ham, can you explain the difference between 18B32 and 18B31?
Madam Vice Chair, Commissioner Quesada, I would be happy to. 18B31 are what we call listed special use permits. Those are subject to Resolution 11686. That's the county's decision-making criteria for special use permits or zone changes. B32 are special use permits for specific use. That's when you reach above your underlying zone into a zone above a certain threshold. Those are subject to Resolution 11686 and two additional criteria: demonstration of unique conditions and community support from folks that live within 200 feet of a property. We have never at any juncture in the previous or this application subjected Mr. Hill to the special use permit for specific use criteria. All we're asking the board to do is consider and approve a winery, and we've put forth, to be frank, very standard findings and conditions for this type of use. Now, we can talk about the philosophy of whether or not you can commercialize land or what have you, but the fact is that Mr. Hill wants to start a business that he needs county approval for to go to the State of New Mexico Alcoholic Beverage Control Department to say that he can produce an alcoholic beverage on this property. And we felt that we found a way to be able to do that, but we could just never break through the loggerhead that we have over this, what I would construe as a technical misunderstanding of the code on Mr. Hill's part. We've not subjected him additional criteria. We're not asking you to let him keep his single-family dwelling. We're simply indicating for purposes of accuracy that he wants a winery and there's a house on the property. And so.
And that's not illegal.
Not at all. The house is never in question. It's about the alcoholic beverage business that Mr. Hill endeavors to start here. And I will say again, the department hopes that Mr. Hill can come to the agreement with us that these minimal conditions that we've come up with, that we've imposed on other properties of similar nature, can be agreed to, and we can help him stand up his business for him and his family. I just don't feel we've ever been able to get there.
Thank you, Madam Chair.
I have a bit of clarity around the commercialization. Like you said, that's theoretical, but does this process and the requirements that were, from what I've heard, what I understand from you today is that these things are in consideration of the neighbors and to follow federal regulations that keep us. But do those things then put the property into some place where they couldn't, where they would only be considered commercial, and then that means larger taxes, larger ability, like he mentioned, selling the product at a higher price because of it being deemed commercial, or it sounds like you're saying it wouldn't
Sure.
be deemed.
Madam Vice Chair, there are some things that would be asked for, like the ADA parking spot as an example. When you do a public accommodation, there's just things that a property has to do. Buffer landscaping to protect the adjacent neighbor. The gentleman came and testified in opposition to the requested use on the property. A lot of times we can just come to sort of a mutual understanding that, like, property owner, you can do your use if you give your neighbors a little bit of a, it's a bargain essentially. I get to do this and I'll give you this so that we can both live in harmony. That's like, as we go through these zoning hearings, that's essentially the balance that we're always trying to find. Does it kick him into like a fully commercial property? I would argue that it doesn't. We're not asking him to go through a full-blown commercial building permit process for his residential structure, for instance. But if he does want to start a business and have employees or customers, as any other business owner would be asked to do in the county and is required by state law, you would have to provide minimum features for a building to meet the county's building code or the fire code. I mean, the things that are developed to ensure the public health, safety, and welfare. But we've tapered these back to such a way that we've come up with the minimal set that we feel could be legally defensible from the county's perspective of, we're not asking him to do things that would be contrary to law, but we're also not asking him to go above and beyond what other sorts of small, locally grown, agricultural-based businesses would be asked to do as well.
Okay, thank you for that.
You're welcome.
Yes, Mr. Grotti, Deputy County Manager Grotti.
Madam Vice Chair, just wanted for the record, the policy structure that staff is describing has been kind of born out of the Southwest Area Plan and the area plans, which really go out of their way to promote agricultural land use. And there has been no instance in the past where the staff has ever denied a winery or any type of business that includes the growth of the use of the waterways, the acequias, and the use of the land, the arable land for agriculture in the area. So almost every request that comes forward to the county are moved forward. There's just minimum standards that we have to have in place. So that, and they're very basic, but just to put it in a broader context, both in the North and South Valley, those agricultural land uses are really something that the community has maintained that they want to endure over the years, and we've always promoted those types of land uses and will continue to, but just a little broader context, because he did bring up the Southwest Area Plan and so on.
Thank you. I do appreciate that for clarity. I do think that, in my experience, the county has always tried to uphold those opportunities for community members. So, any further discussion, questions?
Madam Chair.
Yes.
So, Mr. Ham, we're being presented up here with two options, essentially. One is to uphold the decision of the CPC, thereby denying the appeal and essentially leaving the property as is. And then the second option is granting an appeal with these staff-provided conditions. Am I correct? And that would allow this winery and agricultural operation to move forward.
Madam Vice Chair, you are correct. There's a third option between those two. You could modify the suggested findings and conditions. That's always within your discretion as the board. I think that the struggle that the department has always had is that we felt that any of the conditions, however minor they might be, would be ignored by Mr. Hill, which would just set up an enforcement situation where we wouldn't be able to issue requisite permits. We wouldn't be able to provide necessary documents for the state of New Mexico for his business. And we'd put him in essentially limbo as far as having an approval but not being able to actually use it because of his failure to comply with those standards. So, I stand in deference to the wisdom of the board with regard to how you all want to move forward. My take on this is that the conditions that we've come up with are very minor, and they would be supportable through the perspective of the county has an obligation to look out for health, safety, welfare, while also trying to find a place where small business owners can make a living.
Thank you, Mr. Ham. Mr. Hill, could I ask you a question on this? So if we were to grant the appeal today, overturning the decision and approving these findings or something similar, would you comply with those findings, such as having an ADA parking space, having 6-foot buffers, the landscape setbacks, et cetera?
All those are commercial standards. Those are not agricultural standards.
So is that a yes or a no?
You're falsifying the codes. And
I'm
very
just
simple-
asking you if you would
hold
comply
on.
with
Let
these
me-
or not.
No, hear me out, okay? You asked me a question, let me give you a straight answer, because it's not gonna be something that you wanna hear. You're falsifying the codes. What county's saying is, well, we're not gonna help you get your winery going at the state level or the federal level. That's a lie. If you stay with agricultural standards, of course you could give me endorsements to state and federal, but you have to stay with agricultural standards. What they did was they infiltrated the codes with the previous winemakers only here in the South Valley, where they paved over their agricultural lands. You can't do that. You can't do that to people, okay?
Okay, thank you,
So
Mr. Hill.
that's, no, wait a minute, I'm not finished.
You've answered
No,
my
I'm not
question. I
finished.
appreciate that.
I'm not finished. So in
what
other
I-
counties,
Sir, I'm gonna have to ask you to
within Bernalillo County,
finish your statement. I don't think we can.
we also have a village center. Do not interrupt me. We also have a village center that they do not pay over agricultural lands. And they use the same standards as the government,
Sir, I'm gonna ask you to, I don't wanna, let's pause and let's.
I think that answers my question, Madam Chair. Thank you.
Thank you. Yes, Mr. Director Ham.
Very quickly, if Mr. Hill wanted to grow grapes for his own purposes on his property, he would need no additional approvals from the county. He could do that today without approval. Nothing's stopping him from doing that. Commissioner, thank you for your time.
Madam Chair.
Yes.
And I just want to say, I would love to grant this appeal with the conditions stated. I think this is a really good compromise that the staff has proposed that would allow agricultural use of this property. It would allow some economic development, some really good things for Mr. Hill and for the surrounding community. But I don't feel like we got an answer to whether or not this was acceptable to the applicant, and that's a problem, so. Thank you, Madam Chair.
Thank you, Commissioner Olivas.
Yeah, thank you, Madam Chair. I guess I'll just close with this. You know, I was hoping today that we could resolve this and that, you know, that this project would go forward, that Mr. Hill would have his winery and his ability to create, you know, economic growth for him and his family. I get it. Sometimes we don't want to have to deal with the rules, or sometimes we don't think that these rules apply to different zoning, but at the end of the day, you know, a business is a business. And we have to ourselves adhere to these conditions and rules that we got to live by. And if we didn't have to, it would be easier. It would just say, yeah, just do what you want. It's all good as long as you don't have no complaints from the neighbors. But unfortunately, we can't govern that way. There's rules that we have to govern by. There's things in place that we have to base our decisions on, whether we agree with them or not. You know, I just wanted to say that publicly, that, you know, we struggle with them ourselves, but at the end of the day, the rules are the rules, and I'll just say that I'm a little sad because I would really like to see this project move forward. Thank you, Madam Chair.
Thank you, Commissioner Quesada. And I just want to state too, I'm a product of the South Valley as well, and my grandfather and my grandma built a home on property there on Pajarito Road, and they intended for all of their kids to get parts of it. But because of similar changes like this, they, you know, new rules and regulations meant that they had to be able to reach the properties in the back. They had to be able to have space that allowed a fire truck to get back there. So, of course, because my father was the first to pass in my family, me and my sisters lost out on that property. I'm thankful that my uncles and aunt still hold theirs. But we can't access that back property where the special tree is that my dad used to hang out on. And that's not ours, and it's part of this process that's necessary and that we have to agree with so that we're living together. So not to, I know nothing softens the blow, and I think you were heard well tonight, but we have to continue to make sure we're doing fair and equitable along everybody. So I move to deny the appeal and uphold the CPC decision. Do I have a second? Thank you. Madam Clerk, please call the roll.
Thank you. Commissioner Benson?
Aye.
Commissioner Olivas?
Yes.
Commissioner Quesada?
Aye.
Vice Chair Barboa?
Aye.
Madam Chair Baca?
Yes.
Okay. Well, thank you for everybody coming out and announcement of the next zoning meeting is not on here. Will be to be determined. And if there's no other business, this meeting is adjourned.